Okay, so for tonight's lecture, today we're going to be going over chapters 28, 29, 30, 31, and 32. And it's going to be a lot about agency, operations, and votings and corporations and things of that sort. I am going to put, I think I already did it actually. I am putting the link. It's already in the chat now because I already did this lecture for the other class. So if you want to um, watch that lecture, it's going to be the same exact material. But if you're going to do that, I want you to hold off for just a minute because I do want to talk about attendance and I do want to talk about the extra credit because I can't remember if I put that in the recorded session for last Wednesday's class. So as far as that's fine, I don't care. So as far as extra credit. Some of you, and I can't remember, which students in which class have emailed me. Some of you are interested in doing extra credit. And although I was not going to do it, I'm going to allow, if you are really interested in doing extra credit to get your grade up, here is the extra credit project. You can pick up to 3 cases from the syllabus, and you're going to do a presentation on, you're up to 3. So you can do 1, you can do 2, or you can do a maximum of 3. For each one that you select, you're going to give me a 5-minute video, an analysis of that case. You're going to tell me the facts, the players, the applicable law, the outcome. Do you agree or disagree with the court? And you're going to give me, you know how we talk about the cases, but you're going to give it to me in depth. You're going to give me more meat and potatoes on that. And it has to be about 5 minutes per case. If you give me, let's say, 2 minutes, and they're great 2 minutes, I will give you a commensurate point allocation. So for 2 minutes, you'll get 4 points if you do a stellar job. So for you to get that 10 points per video, you need to give me about 5 minutes of solid stuff. But if you give me 5 minutes of BS, you're not going to get 10 points. So you need to give me, meat and potatoes, give me the substance that I'm looking for, give me the analysis, give me the applicable law, give me why you agree, give me why you think the judges or the court decided the way it is. Talk about that case for 5 minutes. And if you do that substantially, you'll get that 10 minutes. And you're allowed a maximum of 3 cases. So potentially you can get up to an extra 30 points added to your exams. So if you have a 70 on the first exam, an 80 on the second, and we don't know what you're going to, get on your third and final exam, and you get that full credit, it's as if that, 70 is a 90 and that 80 is also a 90. If I apply those 30 points to those 2 exams, it doesn't really matter how I do the allocation because each exam is the same percentage as far as weight. So I'm going to just be adding the points at the very end anyway. So for the 3 exams, I'm just going to add the points to it at the end. If you are interested in doing the extra credit, you need to email it to me. Nope, there's no writing involved. It's just there's a couple of different, Poppy, my chat messages here. No writing involved. It's just a pre-record, video of you talking about the cases. I'm not going to send an email. That's why I'm talking about it now. So you can email me the videos. If it's a big thing, you might have to upload it to YouTube and then send it to me that way, because sometimes I've seen in the past students are saying that it's too big to send out because of the whatever, it's a video. So you have to find a way to get it to me, whether it's a YouTube link or you upload it to something and I download it, that's fine. And it has to be before your final exam, because I need to be able to, once that final exam hits, I need to devote my time to now finalizing your grades, because I have a deadline that I have to submit all grades to the World of CSI to. So if you're going to do the extra credit, it must be before the date of the final exam. Again, you can do 1, you can do 2, or you can do a maximum of 3. And that's if you've obviously taken, all 3 exams, or you're planning on taking all 3 exams. So that is for the extra credit portion. Does anybody have any questions about the extra credit? Also, do not find a website that talks about it and copy or kind of memorize what they say and then read it, or find a website that has a synopsis and read from that website, because I'm crazy like that. I will find the website you're using, and if you're cheating on your extra credit, I'm going to not give you any points and I'm going to be pissed off. So this is something that's supposed to be an analysis. My recommendation to you is that you kill two birds with one stone. Do cases that are on that final third of the syllabus, things you're going to be tested on anyway for your final exam. That way you're studying for the exam and getting extra credit at the same time. So you can actually, help yourself doubly that way. So when it comes to studying for the exam, you don't have to do that. Should I just make you guys watch what I just said? Okay. For the video, you need to give me who the players are, meaning who are the parties in this particular case. What is the fact pattern? Who is suing who over what? What is the legal principle involved? What is the legal analysis involved? What did the court conclude? What was the outcome? Why did the court rule in the way that they did? And do you agree with that outcome based on what you learned, based on the legal analysis that you have? So it's kind of like the synopsis that we do, but it's just going to be a lot more involved because you have to speak for 5 minutes about a particular case. But again, if you speak about, 3 minutes, you'll get 6 points. That's better than nothing. But you can talk about your opinion and why you think that person is right, or why they think they're wrong, or why do you think it can be looked at different ways. Play devil's advocate. Just talk about the case in your own words, of course. You got it. Anybody else have any questions about the extra credit before I move on to attendance? Okay, so now for attendance, this should be your 9th class of phrases. You don't forget the first day I took attendance, so you don't have a phrase for that first day. Every lecture since, whether it's been a question or a secret phrase, you've written something down. So for today, after I give you that secret phrase, you will have a total of 9 phrases if you've attended every single class. At that point, if you have that 9, you can email it to me and put in the subject line attendance phrases, put down business law 160, and I prefer if you put down Monday night. That way I know if it's a Monday night or Wednesday night class. That way I can put down what you're going to get. Like if your 10% essentially will be now concluded because I can just put that grade in for you. If you don't have the 9, we'll have class next week. So you can wait until you get next week's secret phrase and include that. The week after, it's going to be the final lecture, and there's nothing on the syllabus. It's going to be an opportunity for us to catch up, for me to answer any questions. So if you are dying for grades, and I'll have another class, and I can just give a secret phrase that last day. But by now, don't forget, there were some pre-recorded lectures where I did not do a live class like this, but I had you watch a video, and there was a question that I asked, and if you answered that question, that's going to be the answer or for attendance purposes. So I believe by now, today is actually the 9th secret phrase or question answered. But again, if you missed one, that's okay. You can just, next week you can attend and just get it then. I recommend you wait until you have the full 9, because that's an easy way to get 100 as 10% of your grade. Okay? So that is now attendance, and that's extra credit. Does anybody have any questions about these two things before we get into the lecture?
You were talking a bit fast, so I just missed it. Do you want us to like attach a Word document of the phrases or just put it in the email?
Either way is fine, as
Okay.
long as you number it, and then you just put down the date and the corresponding phrase and or secret message.
Okay, sounds good. Thank you.
Thank you. Okay, so I'm going to just get into the lecture. And again, I just put it, if for those of you who came in late, the lecture, as far as material is concerned, I did put a YouTube link in the chat. So if you want to get off and watch it on your own, I think it's probably less distraction on that one. I might have only had one kid that day, so I already could hear the craziness. So I do apologize in advance. Okay, so today we're going to talk about. Hold on, I just gotta yell at them 1 second because it's. Okay, so today we're going to start with agency. And agency is it's it's the basis. It is the underlying concept of partnerships, corporations, business agreements for everything. Why? Because it talks about basically a relationship that exists between these two entities, between these two people. And so it's a fundamental way to understand how those relationships are supposed to be between those two parties. And when we talk about the two parties, we're just starting out with two parties, but it can obviously grow if you have a corporation or a company that has more than two people. But when you think about agency, the simplest way to understand it is when it's broken down to kind of just two people and how they act with one another. And what agency is, it's a consensual relationship where one or both people, they act on behalf of the other and or the principal entity in order to have like legal rights and duties. And so when I say, hold on, I'm gonna go hide. Hold on 1 second. Okay. So when we talk about agency, think about a consensual relationship between two entities that want to work with one another and whose interest or any decision that they make will impact the other person and the fundamental organization that they have. So, when we break it down again in its simplest form, think about a partnership between two people. Two people decide that they want to get into business with one another. They're both partners. They both have equal rights. They both have equal say in the future of this organization. So if one person decides to go out and make a deal with a third party, what does that do? It binds the other person, it binds the partner, and it binds their organization. So now their organization is liable for payment to this third party. So agency is you're no longer just responsible for your own actions, you're actually in tandem with this other person. When you get into a business partnership with anybody, you need to make sure that you both are on that same page, that you're getting into a relationship with somebody that you trust, that's going to have your back, that's trustworthy, that's honest, because you don't want to get into a relationship with somebody that's going to end up screwing you financially. And I've seen that happen many, many times in the course of working in the courts, where one person binds the other. One person signs the other person's name and makes them a personal guarantee for things for the business when the partner didn't have any idea about it. And now their house is about to be confiscated because of a fraudulent transaction. So you want to be careful whenever you're getting into a business relationship with somebody else. Family, you can't control, right? Family, you're born into. You are stuck with them for the rest of your life. But business relationships, you can pick and choose who you're going to be getting into business with. So, again, agency is a consensual relationship where one person is a representative of or can act on behalf of another, and they have the power or the legal right to affect the other person or the entity itself. It's if you're dealing with that one agent out of two, it doesn't matter. You might as well be dealing with the other person because one represents the other, one represents the organization itself. So that's kind of the breakdown of agency. When we talk about agency, agency has two parts, obviously. It has an internal component and it has an external component. And that really just means that, you are responsible for the act of the other person internally in your organization, and you're also perceived to be responsible to third party companies or entities or whatnot. When we talk about authorizing an agent to do things, they can only do legal things. Okay. So you've heard that before, right? When we're authorizing an agent to act on the organization's behalf and they have the ability to do so, they can only delegate or give authority for the agent to perform legal actions. You can't hire somebody to kill off your enemy, your arch nemesis, or your biggest competitor in the business, or to assault them, or to steal from them, or to burn down their factory. You can't do that because those actions are illegal in nature. So you can't hire an agent or tell your agent to do that on behalf of the business. Can't do that. You also cannot delegate personal services. And that should also be ringing a bell when we talked about contractual obligations with one another. Rather, see the contracts, now agency and business stuff, it builds upon the contractual things that we talked about that second third of the semester. So when you're delegating duties from your business or your partnership, you cannot delegate personal things. So again, if I hire somebody to draw me or to paint me a particular sculpture of some kind or something that has to do with the artsy world, and I'm hiring a particular person to take that project on for me, I'm hiring that specific person. I don't want their understudy to do it. I want that particular person. So it's a personal thing, it's a personal taste, it's a personal desire. You cannot pawn that off on somebody else. When we talk about the realm of agency, there's two different types of relationships. And this is something I want you to know. So this is a write it down moment. If you haven't been writing anything down, this is now where I want you to write. There's two different types of relationships. One is the employer employee, and one is the principal slash independent contractor. Both employer employee and principal independent contractor are types of agencies, but they have there's a substantial difference between the two. When we talk about an employer employee relationship, the employer has control over the employee. They have a control over the way they do their work, the type of work they do. They can tell them what to do and how to do it. Different than a principal independent contractor relationship. It's also an agency. The independent contractor is doing work on behalf of the principal, but the principal isn't telling the independent contractor how to specifically do their job. They tell them, I want this thing done. It's up to the independent contractor to figure out the mechanism on how to do things. And if we were to give examples of these two types of things, think about an employer employee is a manager and a fry cook in a restaurant versus a contractor and a subcontractor in a house, or a hospital and a doctor in that setting. So the employer employee, when you think about it, the manager is telling the cashier what to do, is telling the fry cook what to do, the way that they're supposed to do things. They can move those employees around. They can tell them, you do X, you work here, you do this, blah, blah, blah. Principal independent contractor, a hospital's hiring physicians to make sure the patients don't die. They're not going to, give them nitty gritty details on, okay, well, you got to make sure that you do this. You got to make sure you don't do that. They're just relying on the skill set of the independent contractor to make sure that they're doing things the right way. Do you understand the difference? If you don't, speak up. Okay. This is something also I want you to know and I want you to write down. It is the agency relationship involves three basic elements. Agency relationship involves three basic elements. They are number 1, assent, A-S-S-E-N-T. Number 2, control by the principal. And number 3, the agent acting on behalf of the principal. The agent acting on behalf of the principal. So those are the 3 things you need to have a general agency relationship. There's no, now this is listening. There's no, oh, Amar, go ahead.
Sorry, before we proceed, so
Sure.
we're back to the employer, employee, and the independent contractor. Does that mean now the principal, in case of the independent contractor, is not liable for the actions of the independent contractor?
That's correct. It actually matters.
Have that a lot at work. It's important for me as well.
Yeah, it's actually it's a very big difference. And so when it comes to torts, a principal is not generally responsible for the actions of a independent contractor. Whereas if it's an employer-employee relationship, then the employer is responsible for the employee when it comes to torts. So personal injury stuff, yeah. So it is a big difference. Good question.
Okay, thank you. Yeah,
You're welcome.
that's a great to know, honestly.
Okay, there's no formalities needed for having an agency established. You don't have to write it anywhere unless you're going to enter into that type of relationship for more than a year. But if somebody's going to be an agent for someone else, they're going to work for them. They're going to have that type of partnership. It doesn't have to be in writing anywhere. It could be oral or it could be in writing if they want to, but there's no specific set of formalities in order for it to happen. You just need to have assent, control, and then the agent just acting on behalf of the principal. The next thing I want you to know, and this is actually for life, this is actually a life thing, and that's when it comes to a power of attorney. You may have heard the document or the name power of attorney. What's a power of attorney? And a power of attorney is a very important document. And what a power of attorney does is it creates a relationship between 2 people. One is a principal, one is the agent. And the principal gives the agent the authority to act on their behalf when it comes to financial matters. It could encompass all of the above: real property transactions, stock transactions, savings, checking account, buying, selling, a number of things. Anything financial, a power of attorney will manage. Or it could just be the power of attorney can just say, I want you to only handle my, writing out checks from my checking account in order to pay bills. So it could have very little impact or it could have a lot of impact. When you give somebody a power of attorney, you need to make sure that is somebody you can absolutely trust. Although recent case law, and when I say recent, I'm talking about the past 20 years, case law has come out that says that an agent is only allowed to use a power of attorney to act on their principal's best interest or on their best behalf. Because what happened was people who were agents that had a power of attorney were using that document thinking that now that money that belonged to somebody else is actually their own and they were doing whatever they wanted with it. I'm the agent. I have a power of attorney. I can do X, Y, and Z. No, you don't. You're only supposed to use the power of attorney for transactions that are in the best interest or what your principal wanted you to do. An incompetent person, once a person becomes incompetent, that power of attorney is no longer viable unless it is a durable power of attorney. So this is a write it down. I always test on this. The difference between a power of attorney and a durable power of attorney is if somebody becomes incompetent, a durable power of attorney is still effective. They're both extinguished at death. But a durable power of attorney allows a agent to continue acting even if the principal is now incompetent, meaning in a coma, meaning that maybe they have tubes in their mouth or in their neck and they're on a ventilator, they're not aware of what's happening. So that's when a durable power of attorney is more important.
And both are inactive in case of death, you said?
Correct. Both become inactive. Now, next thing is, what's the duties of an agent to a principal? If you are the agent to a principal, what are your duties? It's obedience, good conduct, diligence, loyalty, the duty to inform, and the duty to account. This is all in your textbook, I'm sure. I've read it there before, so I know it's in there. I'm going to say it again. As an agent to a principal, your duties are obedience, good conduct, diligence, loyalty, duty to inform, and duty to account. The most important thing is you act in good faith towards your principal. Don't screw them. You got to have their best interest in mind. If a potential conflict of interest arises, you have to let the principal know. Hey, listen, this is something where if I do X, Y, and Z, yes, it was a write it down moment. So yes, the duties of an agent to a principal are okay, I'm gonna just put it in your thing. Hold on. Let me copy and paste. So duties of an agent to a principal. 1 second. Okay. So if there's a conflict of interest, this is a listening. Conflict of interest. You have to go as the agent and actually let the principal know that there's a potential conflict of interest and basically get their blessing to proceed with whatever possible conflict of interest may arise. Because again, your duty is to that principal, to that fiduciary. You can't steal corporate opportunities from them. You can't steal business opportunities from them. You exist for their well-being. What is the principal's duty to an agent? What's the principal?
Compensation.
Compensation. Reimbursement. I'm going to put this in your chat too. Indemnification and good faith. So duties of a principal to an agent, they have to pay the agent. They have to reimburse them if they pay anything out of pocket. They have to indemnify them. If they get in trouble for doing something that the principal says, they have to take care of that. And they also have to treat them with good faith. The principal should also not want to screw the agent. Another write it down moment. What terminates an agency? What terminates an agency? Death and incapacity unless you have a durable power of attorney. That's what terminates it. So what will terminate an agency? Death or incapacity unless you have a durable power of attorney. Also, agency is basically good until the two people say it's no longer good. Right? So because it's a consensual relationship between the parties. So if one side says, I don't want to be your agent anymore, it's done. If both sides agree, done. If both sides went into it for a particular goal and that goal has been achieved, it's done. Okay? And that takes care of everything on chapter 28. Okay, so we're going to move on to chapter, let's see here, what chapter we have next. Chapter 29. Okay, chapter 29 talks about authority. And when we talk about authority, we're talking about, this is listening, not writing. There's actual authority and apparent authority. And actual authority is authority that was actually conferred upon the principal by the agent. You have the duty or you have the authority to do this for me, based on this. Apparent is basically like it could be reasonably inferred that this person has the ability to act on behalf of the principal. Ratification. This concept should ring a bell to you. If as a principal, I tell my agents, you only have authority to use X, Y, and Z companies when making purchase orders. So I authorize them to only use X, Y, and Z. And my agent, when making their purchase order, they actually used A, B, and C. After I find out they did not have the authority to do so, but after they found out, I said, you know what, it's okay. We'll keep the stuff that you ordered anyway. I just ratified their action. They did not have the authority to do this, but I know that they didn't have the authority, but I okayed it. So now it's okay for them to have done that act. So ratification. Okay. Let me see here. Don't worry about this stuff. Okay. Who wants to tell me about Reuben versus Yellow Cab Company?
I can.
Okay, go ahead.
I'm just trying to remember. I read it
Sure.
yesterday. Ruben, he was driving and then he crossed the path of a yellow cab driver, and then the driver got very upset, and then because the two cars ended up hitting each other, so he went down off his car angry, and then he hit Ruben with a metal pipe on his head and his shoulders. He caused injury for him, and then Ruben sued him personally, sued the driver personally, and sued the yellow cab company as well. And then the court ruled out in the favor of the yellow cab company because the cab driver was not, when he hit Robin, he was not acting in the employment sorry course of his course of employment. So that's why they said that the yellow cab, by him hitting, it was not a part of his employment. His job is just to drive people around, not to hit if they got angry. And that's why he lost when it came to the yellow cab company only.
No, excellent. Very good. Does anybody have any
Um,
questions?
yes. So
Ahead.
so it's a more so the case. 'Cause I read the case, but that was what got me confused. So that means the Ruben lost the case because the yellow cab taxi driver wasn't like the company wasn't responsible for the actions of the cab driver.
Because it was outside the scope of employment. So this is based on the theory of Respondia Superior. So it's kind of like I hired this, if he was to get into a regular car accident in the scope of his employment, then the car company would be responsible. But because he acted outside the scope of employment, things that he wasn't supposed to be doing anyway, the cab company was not found responsible. So the example I usually give is if I have I'm painting my house, or I've hired a company to paint my house, and I sent out one of my employees to go pick up paint or to go pick up something that we need to complete our job. And when they go out, they're supposed to go this way so they can pick up the paint, but instead they took the company car and they went that way to pick up their dry cleaning. They didn't tell me. And while they were doing that, they got into a car accident. I'm not going to be responsible. They're going to have to take that responsibility on their own because I sent them so they can go pick up paint for the job, not so they can use the company car for their personal errands. So Respondia, the Reuben versus Yellow Cab Company, is the theory of Respondia Superior. So the employer is responsible for the acts of their employee as long as the employee was in the scope of employment. That's important. That's something you should write down. So Respondia Superior is that legal theory that says the employer is responsible for the acts of an employee so long as the employee was in the scope of employment. And the best example of that is the case of Reuben versus Yellow Cab Company. Does it make more sense now?
Yes, it does. 'Cause I was looking at it from the like types of relationship where the
Gotcha.
employer is responsible.
Gotcha.
So the theory is the employer is responsible for the employee so long as the employee acts
In the scope of
yeah,
employment.
in the scope of employment.
Yeah.
Okay, thank
And
you.
it's called Respondia Superior. That's the Latin term. And I think that's actually the only things I want you to know on this chapter. So what I'm going to do is, because I don't want to forget, I'm going to give you the secret phrase for today. Okay. And for today, it's going to be, the nice weather makes me feel joyful. The nice weather makes me feel joyful. One more time. The nice weather makes me feel joyful. Okay, let's see here, what else? Hold on, I'm multitasking. Okay, so let me close this out now. Okay, chapter 30. Now we're gonna, oh, okay. The nice weather makes me feel joyful. Okay, now we're gonna get into corporations, business partnerships, LLCs, solo proprietorship, and what are the factors affecting choice, what the differences are, things of that sort. There's a lot of different types of entities that you can create if you want to get into kind of business for yourself or with others. You can do something where it's just you, a solo proprietorship. And a solo proprietorship is unincorporated. It's one person that runs everything. There's no formality. There's nothing to file. That person is taxed, as an individual. When they die, that entity dissolves, and that's it. It's like if you're running an eBay store or an Amazon store or Poshmark or anything like that, right? It's just you, yourself, and you, nobody else. There's also partnerships, and there's different types of partnerships. But before I get into the partnerships, the limited liability companies and the corporations, there are factors that people look at to determine which one of these things they should actually create. And the factors affecting choice are, write this down, the factors affecting choice are ease of formation, federal and state income,
You mean tax
tax,
income?
yes, external liability, meaning who's going to sue you, management, the transferability of ownership, and finally, continuity. So again, the items are ease of formation, federal and state income tax, external liability, management, transferability of ownership, and continuity. Now this is listening. Taxes and tax implications is probably one of the most, if not the most important factor, because depending on the type of entity you form, you're either gonna be taxed directly, or the corporation is gonna be taxed, and then it's gonna be passed down to you. Is there going to be double taxation? Are individuals going to be taxed? If the entity is going to be taxed, do you have write-offs if you are going to be doing an entity like that? I don't know the tax side of it. I don't profess to ever know it, but I know that different types of entities have different tax laws, rules, and regulations. So if you are going to be creating any type of business entity, you want to look at the tax implications between the different entities before you decide as to which one you're going to do. The next thing is sole proprietorship, which I talked about. The next thing is what's a general partnership? And when we talk about a general partnership, it's basically just two or more people that are working together for profit. There's no formality, there's no paperwork that's going to be filed with the state. Each partner has a right to control the partnership. Your book, FYI, has more things that I'm going to tell you. I'm going to just highlight the ones that are more important and the ones that I see as the most relevant. There's also something called a limited partnership. Limited partnership. And a limited partnership, again, it's not incorporated. It has one general partner, one limited partner, and it can decide whether it's going to be taxed as a separate entity or if the partners are going to be taxed directly. Some publicly traded limited partnerships are subject to corporation tax. So you could have a limited partnership that's publicly traded. Most, however, are private entities, mom and pop, a couple of people working together as an LP. The next one is the most common, and I want you to know that. The next one is an LLC, a limited liability company, and it is the most common type of business entity. A limited liability company, LLC. It's unincorporated. It has limited liability to its owners, which means they don't get sued directly as individuals. The company bears that lawsuit aspect, but each of them can have management and control in the business. So it's kind of like they say it's the best of both worlds. You can be a partner, you can manage, you can control, but you also get to shield yourself from third-party liabilities because it's the company that has that face, it's the company that gets sued, not you as an individual. The next one, just the listening, it's an LLP, limited liability partnership. And that has to be filed with the state. Usually there's an application that requires specific information. And the last one I want you to know is a corporation. And a corporation is legally a separate entity. It is completely distinct from its owners. And it bears 100% all the liability from third-party entities when it comes to lawsuits or responsibility. When we talk about partnerships, when we talk about LLCs, you have a duty, this is listening, amongst partners. And that is premised on the theory, again, of agency. So each person in a partnership or in an LLC, they have a fiduciary duty to one another. They have to be loyal to one another. There's that duty of obedience, duty of care. It's a fiduciary responsibility that they have with one another. Case law from a long, long time ago sets the precedent that you have to have the utmost loyalty and fairness and good faith when you have a partnership. You must deal with each other in that respectful way where you both, again, are loyal to one another. You're sharing in the profits and the losses equally unless an operating agreement says otherwise. I'm just looking to see. So I'm going to talk about it now because I don't want to forget. I mean, I might be talking about it a little bit later on. I don't see it in my notes right now, but whenever you form a business relationship with another human being, whether it's 1 or 10 or 100, have an operating agreement, have bylaws that are written down. It doesn't have to be filed anywhere. It is simply a contract or think about it as a memorialization of your understanding with one another as to how you're going to handle certain situations. An operating agreement or bylaws basically says what the partners are going to do, what the owners of the entity are going to do in case of X, Y, and Z. It talks about the voting rights. It talks about who is eligible to vote. It talks about how you bring another person in. It talks about resignation. It talks about when somebody dies. It talks about how to value the asset itself and selling it. It talks about accrual of debt. It talks about creditors, profits and losses and responsibilities and whether there's going to be payment and whether there's going to be loans. It could talk about everything in that particular document. And the reason why it's so important is because it gets the partners talking and discussing with one another what they're going to do in case of X, Y, and Z. And to have a good document, you need to have somebody that's going to ask these questions. What are you guys going to do when this happens? What are you going to do with this? That way it gets them talking, the partners talking, so they can decide and have it on pen and paper. I talked about in my other class this case that we had, and it's finished. It's settled now, so I'm able to talk about it. Although I'm not going to mention any names. It was a business on Staten Island, and it was a very, very, very lucrative business. And it basically was two families, and the two families each had four members in that family. It was like a oil refinery business type on Staten Island. The dividends alone every quarter were hundreds of thousands of dollars to each person. Hundreds of thousands of dollars every quarter. So every 3 months, you get a check for a few $100,000. Okay, let that sink in. So there's two families. In one of the families, one of the persons died. He left a will where he left everything to his partner. The three family members that were surviving did not want to have this other person join in with them. They didn't want to deal with him. They didn't want him to be part of the business. They offered to buy him out for $1 million. And at first he said yes. And then once he hired a lawyer to just kind of do a consultation, he quickly realized, why would I sell my interest for $1 million when every quarter I can get a couple of $100,000 in a year or so, I can get that $1 million plus. The case went and it was litigated for a very long time. The problem was in the bylaws, in the operating agreement, it did not take account death. What happened when one person died and how that interest would be actually given off. First, they did this thing where they're like, oh, the company's not doing as well as it used to be. First, actually, they would pay off dividends to themselves and not to this fourth person because he wasn't working with them. Then they were like, oh, when the court said, no, you have to pay him dividends, he's a shareholder. Then they're like, oh, there's no more money. We're actually reinvesting. That we made a business decision to just invest everything back in the business. And this person was kind of like screwed out for a little while. And so it's important. You would think with a company that's so lucrative, they would have had all their I's dotted and T's crossed, but not always. So again, it doesn't matter what kind of business you enter into. Ask as many questions as possible or hire an attorney that's going to ask as many questions as possible. That way you get all these things. And everybody always thinks, well, we're going to get into business. We're going to be super filthy, super rich. You should always take the worst situations possible and decide what you're going to do in those situations because that's how you're going to be able to avoid litigation, which is very costly, very time consuming. Okay. That's everything that I want you to know about chapter 30. I have 31 and 32 left. Okay, so chapter 31, you've now set up your business, you've worked it for a little while, and now you are done with your business and you are going to dissolve it. How do you actually dissolve the business? Well, businesses are depend on how you have it written in your operating agreement or in your bylaws, but if you're liable to third parties, you have to pay them off. Usually you have to kind of like you take all the business assets and then you'll see what liabilities you have and you'll kind of do it that way. And if there's any money left over, that's profits and losses. That's depending on what the bylaws operating agreement says, the percentage. Somebody like sometimes also you have a situation where you have let's say the business entity was started between two people and then a third party comes in to join, like a third person comes in and is now part of that business. Well, that person is liable jointly and severally for whatever proportion that they own. They may not be responsible for that debts that accrued into the business prior to them coming in unless that was that type of agreement. So a liability of an incoming partner, they may be responsible for old debt, or maybe their contribution kind of wiped that away, but they're usually responsible for any debt that comes in after they have joined. What's the effect of dissolution when you like terminate a business? Everybody kind of just goes in their separate ways. There's no longer that fiduciary duty. There's no longer that business entity that you have to kind of keep in mind. How do you wind down or wind up a business? You basically finish anything that's undone. You collect all the debts, you take inventory, you reduce assets to cash, you audit books, you pay creditors, and then you distribute the remaining assets, if any, to the partners. How do you actually bring about a dissolution? It could just be the simple act of the partners. Perhaps it's already written in the bylaws or in the operating agreement, or it could be a court order that says, okay, this business has to now be dissolved. And that's all I want you to know for chapter 31. I'm going to move on to chapter 32, which is how do you file, a limited liability partnership? How do you file a corporation? Actually, I could probably just show you that now. Let me see here. I did this recently, DOS.
On the corporation website.
Yep, I'm just getting it here. Okay, so I'm going to put it in your control copy. It's actually for fun. If you'd like, you can actually take a look at this website, and this is for New York. And if you go to the I would like to, there's like a form a limited liability company. And if you click on that or the corporations, you can click on all that stuff and fill out the necessary forms, file what you need to do, and you could create your own business. You file it with the state. Some of it is pretty simple. It's not very, very difficult, but for fun, you can take a look at that if you are interested in having your own business at some point.
And then you have to go to a different website to apply for the tax ID.
That's correct. And you could only apply, you're supposed to apply for the tax ID once you have that business ID. And getting a tax ID is also very, very easy. It's like if you go to the irs.gov, it's called an EIN. You apply for it, it gives you a bunch of questions and they email you your EIN number right then and there. So if you're thinking about having a business, you can actually just do it while you're in class. Okay, what else do I want you to know? Okay. Okay, formation. So there are certain entities that have to be filed with the state, like limited partnerships, LLPs, LLCs, corporations. You file the certificate, you basically write down the name of the organization, which address service is going to be upon, and that's pretty much it. You don't usually file the operating agreement or the bylaws with anything. It's more of an internal document. You also there's nothing about voting rights that's usually filled out. The voting rights, and this is actually I'm going to talk about it, and I do want you to know this for life purposes. I'm not sure if I'm going to test. Actually, I'm going to test on this. So write this down, or at least listen to it. No, that the employer. Oh, you're going to put that in. Is that what you're doing? Employer tax ID. Okay. Voting is really important. And I always talk about voting in elections, but also when you talk about voting in a corporation or a business entity, how that's broken down, that's also very important. And I'll tell you why. If you have a business entity that has 10 directors on it, and you say that in order for us to conduct any type of business, we need to have a majority, a simple majority. So for whenever you have meetings, you need to have a simple majority. So based on 10 directors, how many directors do you need if you're going to have a simple majority? Correct, 6. Now, in order to have anything passed, you need to also have a simple majority of those present. How much would that be? So out of the 6, another simple majority. How many in order to effectuate a motion? 4. That's right. So out of the 10 directors that you have, you only need 4 people to pass a motion. That's not really a majority, right? It's only 4 people out of 10. But that's why it's important to see what your bylaws say. And you could have 2/3, you could have 90%, you could have a simple majority, you could have 2/3, you could have all those things. But you are the trajectory of the corporation, the company, the business entity is going to be navigated by what your directors are going to be voting upon. And so you can have things that are voted upon that only require 4 people out of 10 based on that scenario I just gave you. So that is voting rights. And so partnership agreements or bylaws or things of that sort usually will set forth the voting rights. What else do I want you to know? Okay. I believe I already said it. I'm going to say it again because I have a little note to myself. It says I test on this. I usually test on this. LLCs are the most popular and widely used unincorporated business. So make sure you know that LLCs are the most popular and widely used unincorporated business. Okay. Okay. The next, oh wait, is this also, wait, I think I'm moving on too fast. Hold on. Oh, I'm supposed to only stop at chapter 32. Okay. I'm not going to go into the duties and liabilities. I kind of, when you wind down, that's basically it. And I'm not going to jump ahead to chapter 33 because that's for next week. So let me just see here. Okay, I think that's enough. All right, does anybody have any questions up on anything that we've discussed so far? Let me look at the chat. Blah, blah, blah. You don't get one W2. Don't you get one on your the EIN on your W2 is usually of your employer. It's their tax ID. When you have a separate business, that business itself has that EIN number. It's their tax ID. It's the equivalent of a social security number for a business entity. Does anybody have any questions on any of the material we covered so far? We basically only have one other class where we're going to talk about chapters 33, 34, 35, and 36. And then after that, one class as a review catch-up, and then your final exam is going to be, I think Amar, you had brought up that there was a error on the syllabus, but
Yeah, it was just the date. It was instead of 20, I think you meant 10. We fixed it last time, I remember.
I don't recall, but I'm going to actually just take a look at my calendar because I think, hold on.
Yeah. It was like, I remember it was saying May 20 and then May 17. You meant to say May 10 and then May 17.
Okay. Oh, because yeah, May 17th. Okay, so May 17th is the catch-up. May 24th is still your third and final exam. So next week, the 10th, we have the 33, 34, 35, 36. The 17th is our catch-up, and your exam is May 24th.
Could you please type your email address on the chat?
Sure, it is already on the syllabus, but I will give you I'll give you my CUNY one. That way you guys have that. But I'll also give you my other one. Everything goes to my phone, so it really doesn't matter how you email me. Okay. Or Bekhit at nycourts.gov. Okay. Does anybody have any questions on any of the material we talked about tonight?
See, I'm having an issue with the voting one because I don't remember I read something like that in the book yesterday.
It's, I mean, they probably don't have the example that I gave because I try to kind of simplify it as much as possible. But when they talk about voting rights, I think they might have just in that chapter, they just talked generally about voting rights. In the chapters coming up, we're going to talk about more of liability and voting. One vote per share. It's on chapter 35. Sometimes I like to explain certain concepts a little bit ahead of time.
Yeah, I just like, because I lost, what did you say to write it down? Because I was confused that.
Don't worry about it because we're going to do that one again next week. I'm going to give, because I always test on like voting on what's the minimum and what's the maximum number of votes that you need to carry out something depending on bylaws, but I'll do another example next time.
Okay, thank you.
You're welcome. Does anybody else have any questions?
I have a question, Professor.
Sure.
It's not related to the lecture, but like
Okay.
in general.
In life?
Yes, yes.
Okay.
Is there a good website or a source like I can go into if I want to look up like, how to start up a business and all that good stuff?
I don't think there's a particular, like, I don't know of a website that I would recommend, but I actually, if you go to the DOS website, hold on, I'm gonna share my screen because I want you to see what I'm looking at. So so you see here where you say, all right, I would like to, hold on, form a business corporation, right? You see how it gives you, tells you it could be formed by X, Y, and Z. Here's the instructions, business professional service corporation. It gives you a little bit of information. It's a government website, so it's like more legit. If you go here, just business corporations itself, filing, how to, and facts, you get a lot of information on the how to and the fact portion. And I think a Google search, if you were to Google some of the terms that we use today or look in your textbook, you would be able to see that, I guess it depends also on the type of business that you're trying to do. Hold on, I made my thing small and I can't make it big. Ugh, I don't know how to do it. Stop sharing. Okay. So if you have a particular business in mind and decide how many people are going to be in your business or your idea, your company, and then kind of start looking up different ideas. Look up solo proprietorship. That's a common one. Look up LLCs, the benefits and cons. Just Google the benefits and cons of forming an LLC. There's also actually different tax implications depending on the state that you're registered in. So Delaware is a very, very popular state for organizations to be incorporated in because of their tax benefits that they have. But if you're not going to be doing business there, can you form a business entity there, or can you incorporate it there if there's no ties? I don't know. I'd have to do research on that, or you have to do research on that. But if you're going to be doing a business in New York, LLC or a corporation, it's more corporate. You get a lot more protection. So the business entity, are you going to be in a business that is likely to be sued also, that you need protection? Or are you going to be just selling things, on the internet that you're going to be kind of creating? So I think a lot of it has to do with the business idea that you have, and then you take that and then you start looking at what would best be for that business entity. And that's why people hire attorneys also. Sometimes you have the idea, you have the business, but now you need to speak to an attorney that knows business and knows taxes. There are some people that have that business acumen and that tax knowledge. And so you're better off doing a consultation, paying a couple of $100 and getting an expert's opinion. That way they can kind of direct you on that right path.
Okay. Thank you.
You're welcome. Anybody else? Go once, twice. Okay, if there's no more questions, I will post this probably in a couple of days, and I will see you guys next week. Have a good night.
Good night, Professor.
Good night,
Um,
everyone.
Good night.
Good night, Professor.
Good night.